Honourable Clayton Cosgrove.
Bridges raised as he spoke as a learned lawyer and former prosecutor, I'm told, in his own hometown. Sorry? Who are you? And we were having a discussion, I believe, Mr Chairman, about the nature of how judges would deal with the issue of hardship and whether, let's be blunt about it, whether they would try and find a way around the imposition of a levy through downgrading, say, fines or commuting fines to community service. And I found Mr Bridges' comments quite astounding because, of course, we do know that judges do get around laws, bluntly, that are put forward in this parliament. If I could use the analogy, I passed one a few years ago about boy races. Only 2% of cases, in only 2% of cases or less, judges took cars permanently. Now, I had advice from the police and learned folks all over the show that this would not happen, that judges would be tough, use the mechanisms within the law we passed to do it. Well, they didn't. And then Mr Bridges made a very interesting statement, which I was quite astounded at, coming from a learned Perry Mason-like lawyer and prosecutor. And was he a defence lawyer, was he? Okay. And it was this. Essentially, Mr Bridges said that judges would adhere and do their job and adhere to the principles of this law because the levy was $50. But he said, had the government set it at $200, then they probably wouldn't. They wouldn't adhere to the law, they'd get around it. Now, I don't think judges normally act that way, and I'm very surprised that Mr Bridges, a learned prosecutor, would make such a claim because in essence he substantiates the point I make. Judges will have the flexibility through the fine mechanism to, as Mr Burrows said, the chairman of the committee, at a very valid point right at the start of his speech. He said that fines can be commuted to community service or prison or whatever. So I come back to this point, that this is, in my view, quite an unworkable piece of legislation, and it will be interesting to see if judges, because no one can guarantee how a judge will implement this law and how a judge will interpret this law. But I still make this claim again, and I'm not defending the offender. If an offender comes before the court and makes a so-called legitimate plea of hardship, and there is a combination of perhaps reparation, fines, and the compulsory levy, then a judge quite legally and quite rightly from their point of view has the ability to alter the fine mechanism, for instance, if they so choose, and commute it to community service. That would be an easy way to do it and still adhere to the law. You'd have your $250, you'd say, Johnny probably can't pay that, I'll make him do community service, but I've got to put the $50 levy on, which I'll do. Now, I asked the Minister, who is also a learned, I'm told, lawyer, if he would rise and tell us how he can guarantee that judges would not use that mechanism, which does not is in adherence with this law, does not break this law at all, does not contravene. I knew he was a good lawyer, he knows the big words. Does not contravene this law, how he can guarantee that that will not occur. I'm quite happy to ask him now. In fact, I will ask him now. I'll yield to the Minister if he'd like to get up and tell us how he can guarantee that a judge won't get around this levy by simply doing what I've said, because it happens every day in respect of fines and reparations, actually. If a judge feels that the reparation's going to be, too tough, sometimes it's done for practical reasons, perhaps a lack of ability to pay, which is noted in this law. But I'd love the Minister to get up. I'm happy to yield to him, Mr Chairman, through you. Happy to give him 10, 15, 20 minutes, half an hour tonight, as long as he likes, to convince this House that this bill will be absolutely operational to the fashion that he is committed to, both in his pre-election policy and tonight. Because he can't give that guarantee, because he is a learned lawyer and a bright chap, I'm told, and he knows that that's impossible, because he's not a judge. And nearly every law in this place, a judge interprets, and often interprets differently. I recall, as Minister of Building and Construction, when I think it was the learned Judge Lynn Stevens, after we'd passed the second iteration of the weather tightness legislation, who I think it was on compensatory damages or something like damages, decided to interpret the law quite differently, Mr Chair,
Mr Cosgrove.
Thank you, sir. Well, I'm happy to yield to the Minister, though, if he's changed his mind and wants to answer a question. In that case, the judge, in respect of damages, had interpreted the law, and I, from memory, struck them out or made certain classes of people ineligible for them, which was, in my view, directly contrary to Parliament's intention. And I recall, as Minister, we did a very, very rare thing, in that we actually suspended standing orders, very rare for this House, and literally punched through a bill with a couple of clauses in it to effectively reverse that and clean it up. And we were advised by the officials that this would not take place, that judges would interpret it the way Parliament intended. Well, they didn't. So I'd make another prediction. I suspect the Minister will be faced with a choice where he has to come back to this House and tighten up this law, because we'll see from the figures, and it'll be quite easy, I think, to analyse where judges are at in terms of commuting fines as a basis of lessening the overall cost to the offender based on a hardship plea. If they were really serious about this, and this bill's intent is about injecting money from offender to victim, from court, if you will, to victims' groups. You don't need the Secretary of Justice to be setting up bank accounts, as in Clause 105F, making decisions about distribution. You have an organisation, just one of the organisations, called Victim Support. The Minister could go tonight to the Minister of Finance. He might be round at his house, cleaning it perhaps, but he could go round to the Minister of Finance's house. He could go round to the Finance Minister's house and he could say, I want $16 million a year. The Minister of Finance might say, hang on, I've got that money. And I know Mr Power could then say, we'll take half the money you're going to give to private schools and we'll dish it out to victims. There you go. Done. Like that. Tonight. $35 million to private schools. Take 16 off that. You're still going to give a bit of money to private schools. And you could directly inject that money to victim support and the other agencies who are highly skilled, unlike that person over there, highly skilled in terms of dealing directly with the needs of victims. No bureaucracy, as the member for Coromandel bleats on, no bureaucracy, no need for this legislation, and then you could use the courts to go and chase the fine defaulters and others. Do things like what we did in government, stop people at the border and say, you're not going to go overseas until you pay your fine. You could do that directly tonight, no bureaucracy. Because this was a minister and a government that railed against red tape, railed against bureaucracy. But if you were really serious, you could make an appropriation of 16 mil or however much the minister claims the revenue will be. I suspect it will be a lot lower, and inject it directly and contract with directly victim support and other NGO agencies who help victims today and are skilled in it. But I say to this minister, and I invite him because it is a very important question, that he ought to stand up and answer and give that guarantee that judges will not contravene this law. Because if he cannot make that guarantee, then it's game over. We know, what is the point, somebody said, of being here tonight? It is game over, and it's game over for victims because this is a sham. And I say to Mr Burrows and the others who interjected on us and said, why then are you supporting this? Well, I say this in the old, to use the words of the former Prime Minister of Australia, Paul Keating, because in accountability terms, we will do this legislation and this government slowly. It will be debated here again next year and the year after as we prove to victims that Simon Power and his government tugged on the heartstrings, raised expectations, and then the member for Coromandel and her ilk let them down. Let them down. But if the minister, I concede, is prepared to get up tonight and make that guarantee as a lawyer, then OK, we'll have another look at it. But we will support this. People have their chance, she said. Well, the people have their chance and have their say and render their verdict on this piece of legislation. And every victim who is let down by this will render a verdict on that member and the minister and their government. And I don't believe, whatever political colour you are, that you should tug at the heartstrings of the most vulnerable. We've heard about ACC, and then try and pull a fast one with this. So we'll support it to use it as a point of accountability with this government. because the truth is they cannot live up to the pledge they make unless, as I've said, they do the honest thing and they go and make an appropriation.
Joe Goodhue.